Pick the wrong title vesting, and your family could end up in probate court, fighting delays, fees, or worse. One checkbox on your closing packet has more legal weight than most buyers realize. I'm Jermaine, your Arizona realtor, lender, and fellow investor. Let's talk about how you take title and why it matters before you sign anything. This process is called vesting. It's how you legally own your property, and it affects inheritance, taxes, and your ability to transfer ownership if something happens. In Arizona, that also includes how community property rules apply if you're married. There are several common ways to take title in Arizona, and each one has its pros, cons, and consequences. Tenancy in common means each owner can hold a different percentage. You can leave your share to anyone, but that often means going through probate. It's common when friends, siblings, or business partners buy together and want different ownership splits. Joint tenancy with right of survivorship gives each owner an equal share. If one owner passes away, the surviving owner or owners inherit that share automatically. It skips probate, but only if it's set up correctly. Arizona is also a community property state. In many marriages, the default is simple community property, where each spouse owns half and can leave their half to someone else in a will. But the estate usually has to be cleared through some type of probate or court process when one spouse passes. Community property with right of survivorship is a special option for married couples in Arizona that combines equal ownership with automatic inheritance, typically avoiding a separate probate just to clear title and sometimes offering tax benefits. In that version, the surviving spouse becomes the sole owner, as long as both spouses agreed to hold title that way and the paperwork is done correctly. Sole and separate property applies when a married buyer wants to keep the property as their own. That's legal in Arizona, but your spouse must sign a disclaimer deed to waive community interest. Some buyers also hold title in the name of a trust, LLC, or partnership. Those structures can have estate planning or liability benefits, but they come with their own legal and tax rules, which is why your attorney or CPA needs to be part of that conversation. So what's the risk? If your vesting doesn't match your intentions, your ownership could be challenged, delayed, or even voided. The title company just follows what's on file, so you want to get it right the first time. If you're buying in Arizona and want everything to stay on track, reach out to me. After you talk with your attorney or CPA, I'll help you review the title and loan paperwork so it all lines up. I can't tell you which method to choose, and nothing in this video is legal or tax advice. That's a conversation for an attorney or CPA who understands your situation. My role is to explain how these options generally work in Arizona and then help make sure your title paperwork matches the choice you and your advisor make. But once you've decided, I'll double-check that your title commitment reflects it exactly. No surprises at the closing table. Still have questions about how to take title when buying a home? Then let's talk. I'm always here to help homeowners and future homeowners like you. Got questions? Call or text me at 480-800-HOME. And don't forget to like, comment, and subscribe for more Arizona real estate tips. Have a nice day.